Now, today, we will provide you with some further insight with regard to which measures belligerents are allowed to take against foreign vessels and foreign aircraft. Where do you look it up if you want to know what you are allowed to do? Well, not targeting only. You look into the Newport Manual. Okay? You don't look into the Law of the Sea Convention. You only look at the Law of Naval Warfare. Is that understood? Good. Remember that for your exercise later on. So, remember the lecture by Captain Fink on the principles. One of the principles being military necessity. And military necessity means everything necessary to weaken the enemy without the least expenditure of your own assets and forces. So if you have an enemy warship, what do? You sink it. That's the best you can do, all right? And you don't get out of the way. You engage it. So, now remember, we are here mostly concerned with objects, platforms, meaning vessels, aircraft. That's what we are concerned with. So we want to know which platforms are liable to be attacked. That is our primary focus. Later on, in the lecture by Captain Pedroso, you will hear other measures that you may take against vessels or aircraft under the law of price. Totally distinct from the law of the sea. You have much more authorities during war. You are a belligerent, okay? It's not all butterflies and unicorns. Those days are over. You are at war. Of course, once in a while it may happen that you also have to target individuals, but that's a rather exceptional situation. The other thing you have to remember that we need to distinguish between attacks from the sea against land, a little bit more complicated, and attacks at sea or in the airspace above. The rules are slightly different, so please keep that in mind. A big difference. But remember, not all states are bound by the same treaties. Many of the countries represented here are bound by Additional Protocol 1. Others are not. So for them, when it comes to attacks against targets on land, we may have to fall back to the Hague Convention number 9 of 1907 and customary law, of course. So, the first thing you will have to do as a legate is to establish which treaties are binding upon my country. And if you have done that, then you know where to go. All right. Now, we are primarily concerned with attacks, okay? Here in this lecture. Later on, we talk about visit, search, diversion, and capture, prize law. Now it's about attacks. And when it comes to attacks, this notion has been defined in Article 49, Paragraph 1 of Additional Protocol 1, which is widely considered to be reflective of customary law. So it must be an act of violence directed against the enemy, and it does not matter whether you commit that act of violence in offense or defense. This is a definition, at least the states party to Additional Protocol 1 must never forget when it comes to attacks against targets on land. At sea, however, it's a little bit different. What is missing? Against the adversary. So yes, we also have to deal with acts of violence, but no longer only directed against the adversary. Why? Because you will later learn that neutral merchant vessels and neutral civil aircraft may be lawful targets as well. And then the attack is not directed against the adversary. So please keep that in mind. So what is an act of violence? If I yell at you, is that an act of violence? No. We are talking about physical coercion, all right? Physical coercion. So it must have effects. And the effects we are talking about is, of course, death, injury when it comes to individuals or human beings, or damage or destruction. Therefore, if there are such effects that you either expect or that the respective attack is designed to bring about, then you have an attack. And then you are bound by the rules of targeting law. This need not be kinetic, because many people believe acts of violence must be kinetic. Think of biological and chemical weapons. No kinetic effects, people die nevertheless, right? So you have an attack. And of course, we could now talk forever about whether and to what extent a cyber operation qualifies as an attack in the sense of that definition. Short answer, well, if it causes physical damage or even destruction in the physical domain, meaning in real life, generator blows up, pipeline is destroyed, all that by a cyber operation, then the cyber operation qualifies as an attack. There is no real agreement on whether a cyber operation that results in a loss of functionality of the target system also qualifies. We are going into that direction, but we don't want to talk cyber now, we want to talk naval warfare. All right, we want to sink ships. And then we can talk about cyber in the break or whenever you want. Now, in order to avoid confusion, because the media, politicians, and others are not always clear when they use the term attack. And we have to now establish what activities do not qualify as an attack. Yesterday, Dave Letts talked about blockade, right? A blockade is a method of warfare. Is it an attack? No. There is no physical damage or destruction to be expected from a blockade. Capture under prize law, you will hear later by Pete Pedroso. You are capturing, if at all, not an attack. No physical damage. Destruction as prize is also not an attack, even though you sink a ship. But that's a very exceptional situation under prize law, when you cannot capture a vessel, you cannot bring it into port, so the only option left is sink it, but remember, first you place passengers and the ship's documents in the place of safety. Not an attack. And last but not least, mine laying for A2AD purposes. You want to deny a given sea area to the enemy. Yes, it's uncomfortable, you don't feel well, but it's not an attack. Okay? However, if you use a mine against an object and you have it explode, then it is an attack. So, but merely laying a minefield for denying the enemy a certain sea area is not an attack. Yesterday there was some confusion about those notions. Okay? Always think of an act of violence, damage, destruction, injury or death. That is what we are talking about. Now, the mother of all principles of the law of armed conflict is the principle of distinction. And this equally applies at sea, even though here it's quoted from Additional Protocol 1, but everyone agrees. Look into the Newport Manual, remember Captain Fink's lecture, is a principle of the law of naval warfare as well. So never direct attacks against an object which is not a lawful target. Okay, if you do that, you are in trouble. Not only your country, but also you personally, because you will have committed a war crime. So that is important. Now, the notion that matters for us, since we are not primarily concerned with combatants, which are individuals with a special legal status, members of the regular armed forces, but now we are concerned with objects, and we have to figure out which objects at sea or in the air qualify as lawful targets. Why do you want to know? Because if you attack lawful targets, what is the consequence? You're weakening the enemy. Is that a legitimate aim? Absolutely. Absolutely. No one goes to war with a view to lose it, right? Or do you? I wouldn't do it. Good. Now, we have a definition of military objectives. Article 52.2 and of the Additional Protocol. Most states would consider this definition to be reflective of customary international law. But not all do. So you see here there are two big elements in that definition. First, contribution to the enemy's military action, and second, well, neutralization, destruction, etc., must offer a definite military advantage. Not a potential, not a virtual, or whatever, definite. Now, if the first element is fulfilled, then the second element will most of the times be fulfilled equally. Now, what does that mean? So the first is an object must make a contribution to the enemy's military action by nature. Which objects make such a contribution because of their nature? Well, all military equipment, all military platforms, wherever they are, outside neutral waters, of course. All right? So, an enemy warship, lawful target? Absolutely. Absolutely. Military equipment? Yes, absolutely. Military barracks? Absolutely. So all that military equipment makes as such an effective contribution to the enemy's military action. Taking it out, destroying it, always offers a definite military advantage because you are depriving the enemy of that object. And as I said before, remember yesterday's scenario, an enemy warship, perfect target. Okay, I want to take it out. Remember Dave Lett's lecture, and you saw the picture of the Moskva that was sunk in the Black Sea? Wow, it's not only a military advantage that you are gaining, but also a political advantage. The pride of the Black Sea sunk. Wow. So, with location, in the context of land warfare, they always give the example of a mountain pass. All right, we don't have to deal with mountain passes at sea. But a harbor, for example, may by its very location make an effective contribution to the enemy's military action. Okay, arguably even a certain choke point at sea, because an area can also qualify as an object, may fall under that category. Let's continue with use. Every object, a civilian object, for example, can become a lawful target by use. For example, a merchant vessel. A merchant vessel is not a lawful target by nature. It's not military. But if the merchant vessel is being used for the transportation of enemy troops, then it makes an effective contribution to the enemy's military action by use. What do you do with that ship? You sink it. You attack it. Or a civil aircraft that is transporting troops or military equipment on behalf of the enemy becomes a lawful target. When we told that Air France a couple of years ago, they nearly fainted. Okay? They couldn't understand it. It's just business, they said. Well, business is good, but take the consequences. And finally, purpose. Purpose is future or intended use. But it's not a question of guessing. Okay, so you must have some hard facts which would allow you to conclude that a certain object will in the near future be used for making an effective contribution to the enemy's military action. One example, you do know that the enemy is about to use merchant vessels flying its flag to transport troops from A to B. Not today, but you know they want to do it the next 2 days. So those merchant vessels would already today qualify as lawful targets. But you need to have facts, okay? Your intelligence community should have provided you with reliable information to that effect. Now, the second is neutralization. I use that as the general term, must offer a definite military advantage. But already from the examples I've given, military platforms, if you destroy them, this will always offer a definite military advantage. If you take out vessels that have become lawful targets by use, well, you are depriving the enemy of their use by sinking them. So very often, most of the times, the two come together. As soon as you have established the first element, effective contribution to the enemy's military action, you are on rather safe grounds that the second element will be equally fulfilled. It's a bloody world, you know, when you are at war. It's not butterflies and unicorns. Never forget that. Now, we heard already about war sustaining. War sustaining is, in particular, a position that has always been taken by the United States. The historic example are the cotton fields of the South, and I already talked about it on the first day as well. So yes, under that concept, an object making an effective contribution to the enemy's war-sustaining effort, arguably neutral merchant vessels exporting important goods, which would then provide, or the revenues of which would then provide the enemy the opportunity of continuing the war effort, they would equally qualify as lawful targets. Remember, in the tanker war between Iran and Iraq, both parties sank neutral tankers because oil was, of course, the most important export good, both for Iran and Iraq. Interestingly, however, the international community condemned the practice of the two belligerents. All right. Now, there are attacks that you should never even dream of. Okay? They are prohibited. Why? Because they are not directed against a specific military objective. If you conduct such an attack, it's unlawful. Or if you employ a means of warfare that cannot be directed against a specific military objective. A blind weapon, so to speak. There are some examples dating back a while. The German V1 and V2, which we fired against Britain. We didn't know, I was not born then, but the Germans didn't know then where it would eventually hit. They just directed it into the direction of what they believed England to be. They had no idea where they would hit. That would have been a prohibited attack under that. And finally, if you employ means of warfare, the effects of which cannot be limited as required by the law of armed conflict, but here we do not have too much practical relevance. So, I promise you we have to distinguish between attacks against targets on land and attacks at sea or in the air. Now let's start with the first. The attacks must, of course, be directed against persons or objects qualifying as lawful targets. When it comes to persons, remember they are individuals who by status are lawful targets 24/7, enemy combatants, whether they are fighting or whether they are taking a shower or whether they are sleeping, they are lawful targets, okay? And if you attack targets on land, the prohibition of excessive collateral damage is important. Because if you are attacking targets on land, they may be expected to also impact upon civilians and civilian objects. However, if you read the rule carefully, you will see it's about expected collateral damage, and you must balance it against the anticipated military advantage. First of all, you have to understand, excessive is not extensive. This ain't a numbers game, all right? So if you expect 200 civilians to be injured and or killed, this is not necessarily excessive. Why? Because you have to relate that to the military advantage you are anticipating. So don't fall into the trap of doing that numbers game. And in particular, no hindsight rule. The media often make that mistake. Oh, there were 200 civilians killed by that attack. Flagrant violation of the law of armed conflict. Hey, wait. It's about expectation and about anticipation. So the commander will have to look a little bit into the future. And if the commander arrives at a reasonable decision that the expected collateral damage would not be excessive in relation to the military advantage he anticipates, or she, then the attack would nevertheless be lawful, even though the number of civilian casualties is very high. And last but not least, if you attack targets on land, at least the states party to Additional Protocol 1 are obliged to take all feasible precautions. Now, feasible precautions have been defined in Article 3, Paragraph 10 of the amended Protocol 2 to the Conventional Weapons Convention. What is important is this is reflective of customary law. Okay? But see what it says. Practicable or practically possible. First thing, not what is theoretically possible. Second, you must take into account all circumstances ruling at the time, and this includes not only humanitarian, but also military considerations. In other words, it does not only depend which weapons the respective armed forces have available as such. You must first ask what weapons does the commander have actually available. And then you cannot even say, oh, now they are only obliged to use weapon X, let's say PGM, a precision-guided missile or something. No, because military considerations also play a role. Yesterday, you had the scenario, remember, there is a warship coming closer and closer. So feasible precautions would mean you must take all feasible precautions to verify whether that approaching warship is a lawful target. But you are allowed to also take military considerations into your decision. Now, what would you do? A warship, you don't know whether it's enemy. What would be the military consideration that you apply when it comes to the question, hey, am I allowed to attack now? Think about it. There's no school solution to that question. But I think, since you yourself remember the scenario, warship A, warship B, you are a lawful target as well. And the closer the enemy comes, the worse for you. They may have long-range weaponry, right? They may have all kinds of devices that will make your life miserable. And a military consideration would be what? Save your ship and your crew. So you don't need to have, beyond any reasonable doubt, evidence that the warship that is approaching is an enemy warship. All right? Really, I mean, you should never forget that. We are not at court here. We are at war. So, the operators amongst you know that operational targeting cycle, right? You are working with this almost on an everyday basis. So, yeah. So you ask yourself, military objective, you assess the target, then you choose the weapon which you may want to use again for an attack against that target, then you clear the target, then you execute the planning, have the target approved, then you execute, then you undertake a battle damage assessment, and then validate it. That's what operators do. All right. Legally, it's similar, but not identical. You can always tell from this, those in blue are what is legally required. The other steps in the targeting cycle are for operational reasons only. For example, you are not obliged to undertake a battle damage assessment, but you of course do it for operational reasons. Good. Now what does that mean? This. Again, remember we are attacking targets on land. Targets on land. Subject to feasibility. So, is the object a lawful target? Yes or no? If it's not, forget it. Don't attack. But if it is, targets on land, then you have to ask, do I expect collateral damage? And then you have to ask yourself, is the expected collateral damage excessive? If the answer is yes, no attack. But you may now change your approach and say, oh, then I use another weapon. And then the expected collateral damage will no longer be excessive, but then you are nevertheless obliged to avoid or minimize collateral damage. Of course, as long as that is feasible. And when you attack targets on land, always expect circumstances may change. All right? I mean, you don't have to calculate in the unexpectable. But you must be aware that circumstances could change, and as long as this is feasible for you, remember practicable or practically possible, then you have to take that into account. So in other words, it's similar to the operational targeting cycle, but the legal requirements are pretty high, okay, when it comes to attacks against targets on land. Now let's go to targets against objects at sea or in the air. Again, of course, equally, all attacks must be directed against lawful targets. Please don't blow out of the water a hospital ship. Okay? This will be also a strategic disaster. However, what about collateral damage? We are not talking weapons of mass destruction here, okay? We are just using conventional naval weapons and weapon systems. Usually, there is no expectation of collateral damage. For example, if you sink a ship, there may be other ships in the vicinity of the target. Yes, it will shake a little bit, but no harm to be expected to the ships in the vicinity. Okay, so if you launch a torpedo against the vessel, then the vessels in the vicinity will not be affected, i.e. damaged or even destroyed. Of course, the question may be, what about civilians on board a passenger liner that is a lawful target? Yesterday we heard about the Lusitania, all right? Nearly 1,200 passengers died from the attack. Now, either you qualify that as excessive collateral damage, because the German submarine commander knew, of course, how many passengers were on board who were innocent, totally innocent, or you take the opposing view to say, as long as the ship is a lawful target, I don't care who's on the ship. Difficult today to maintain that position. Okay? But this is one of the rare examples where you have to expect collateral damage at sea. However, don't forget the environment you are operating in. There may be marine communities, right? People living at sea. Okay? Then you will have to expect collateral damage if you're firing with your guns at an enemy warship that is in the immediate vicinity of that settlement. All right. But in other circumstances, regularly not. And equally, as with attacks against targets on land, you are required to take precautions in attack. But here the question arises, including for states party to Additional Protocol 1, which standard do I have to apply? Is it feasible as defined, or is it only reasonable? And in my view, the standard of reasonableness is less strict than the standard of feasibility. Why? Well, because there are not too many civilians and civilian objects that may be impacted upon by your attacks under the law of naval warfare. So, I think, if you remember that from attacks against targets on land, so here, since there will usually be no expectation of collateral damage, you will, of course, have to verify the legality of the target you want to engage. Yes, you must be aware that circumstances might change, but even that is not all too problematic. So very often, if you have verified the legality of your target, you are pretty good to go. Okay? Pretty good to go. Apart from the question which standard applies. Which, of course, then means, well, okay, having identified a ship or an aircraft which is a lawful target, you're good, okay? You're good. However, remember, I think, Dave, you talked about it yesterday, the British admiral in the Falklands War. He had good reasons to assume that the aircraft that had been detected was the lawful target. He even had gotten clearance from London to take it down. But he had a gut feeling and said, I'm not so sure. Should I really take it down? And he was lucky that he didn't, that he eventually decided against it, because it was a scheduled passenger flight. And for that reason, had he taken it down, remember the Vincennes incidents and all those other incidents, wow, It would not have been unlawful, but the strategic impact of taking down a civil aircraft with 200 plus passengers on board, not good, not good, all right? Here you see there are also other considerations that may come into play. Now, what lawful targets do we have at sea and in the air? Remember the definition. So if you have enemy warships, if you have enemy military aircraft, if you have naval auxiliaries, they are all lawful targets. All are lawful targets. Do you have to warn them before you attack? Of course not. Of course not. That would be stupid. Hey, I'm going to attack you. Ah, thank you. Getting out of the way, right? No. At sight, you can engage them. Of course, you don't do it if they are in neutral waters. Please don't. You will start another war with the neutral state. All right? But what many people misunderstand, also in the context of land warfare, there need not be an immediate threat with those platforms. Remember the General Belgrano in the Falklands, an Argentinian warship that was heading away from the Falkland Islands, so far away from the area of operations? Was it lawful to sink her? Yes, it doesn't matter. She could have been sunk while outside the territorial sea of the Republic of the Philippines, had she been there. All right? So, therefore, there's no need for the ship posing an immediate threat to you. What matters is military advantage, yes or no? And the answer is always yes. Enemy merchant vessels. Remember, an enemy merchant vessel is a civilian object. So you are not allowed to attack them. However, as I've said before, they may become lawful targets by location, purpose, or use. Apart from that, enemy merchant vessels are always liable to be captured under price law. Wait for Pete Pedroso's lecture. Okay? So, sinking a merchant vessel may be very lawful, provided it is making an effective contribution to the enemy's military action. Remember the submarine protocol. And here you have to understand that we have an additional category of lawful targets under the law of naval warfare, additional, I mean, to the definition of military objectives. Persistent refusal to stop, or active resistance. Yesterday you talked about visiting and searching of a vessel. And if a vessel persistently refuses to comply with your legitimate orders, bad for the ship. They shouldn't do that. Okay? So therefore, they become a lawful target. And the same if it renders active resistance. And that holds true for both enemy and neutral merchant vessels. So an additional factor that you must calculate in when it comes to the question of whether a vessel qualifies as a lawful target. Many people unfortunately forget that category. All right? Of course, you may ask, what does active resistance mean? Well, it could be anything. The ship could engage in dangerous maneuvering. Okay? That's active resistance. They need not commit acts that may result in damage or destruction or death or injury. Okay? Resistance. You are allowed to go on board And if they render active resistance, now there was a misunderstanding, I think, insofar as the right of an enemy merchant vessel, to defend itself against lawful belligerent activities. Yes, they have that right. But this is not relevant for whether they qualify as lawful targets or not. It is relevant for the criminal consequences for the master. In the First World War, we had Captain Fryatt, the master of the Brussels. He was prosecuted by German authorities for having been a franc-tireur. Why? Because he wanted to ram a German submarine. Active resistance, right? That rendered his ship a lawful target. But the question you have to distinguish from that, were the Germans allowed to prosecute and eventually execute him? So a totally different question. Short answer, no, because it was an enemy merchant vessel and they had the right to resist, but it nevertheless made the ship a lawful target. I'll say, keep those things apart. So, remember, this has been confirmed by the Nuremberg Tribunal in the case against the German Admiral Dönitz. And the court also held, very important now, that if an enemy merchant vessel is armed, it is a lawful target. Even though they are not using their arms at the point in time, but being armed renders them a lawful target. So the Nuremberg judgment has added yet another category. And finally, if they are integrated into the enemy's warning or intelligence network, we would say today, then they would also be a lawful target. Or if they are sailing under orders to ram, meaning more or less sink, submarines by ramming into them, they would also qualify as lawful targets. So some may say, yeah, but those are old cases from the Second World War. Look into national manuals. And now look in both manuals, Sanremo and Newport. They both agree that all those activities will render a merchant vessel a lawful target. You have here Newport Manual, paragraph 863, telling you which activities render an enemy merchant vessel a lawful target. And what do you see? Refusing to comply with belligerent orders or rendering active resistance. The same in the Sanremo manual. No differences. This list is not exhaustive, to be quite clear, because imagine, for example, a merchant vessel engages in malicious cyber operations by, for example, GPS spoofing. Your warship is no longer able to navigate safely. Yeah, would also render that merchant vessel a lawful target. So there are many examples which you find there. Also, traveling under convoy of enemy warships indicates that the vessel is not willing to submit to visit, search, etc. Well, that's more than enough. Almost identical are the activities rendering civil aircraft, enemy civil aircraft, lawful targets. It's almost the same, Of course, in the air, you don't undertake visit and search, right? I mean, you have to force the aircraft to land, unless you are James Bond or Tom Cruise or so. I mean, they can do that. They can't. This is bullshit, all right? So, neutral merchant vessels, remember I told you in the beginning, they may also qualify as lawful targets by use. So again, you have a non-exhaustive list of activities rendering a neutral merchant vessel a lawful target. So if they do any of these things, they shouldn't complain that they are being attacked and eventually sunk. And the same holds true for neutral civil aircraft. Okay? Now, just for the remaining time, few words about submarine cables, because people are obsessed with submarine cables nowadays. Of course they are. But remember, now we are at war. Now we are at war. And if you look at the law of armed conflict, at treaty law, you only have one rule in the Hague Regulations of 1907 that only says something about cables connecting occupied territory with neutral territory. That's all the rule says. Nothing more. And if you take that as the given rule, then you will understand, wow, if there is a cable that is connecting enemy territory, which is not occupied, you are allowed to destroy it. And guess what? During all world wars, that's almost the first thing the belligerents did, cutting the cables. Of course. And today it may be even more important. I mean, those are here the good old copper cables. Today we have fiber optic cables. Of course, since those fiber optic cables are an element of a network, so no longer serving only the states that are physically connected, but also serving other states, cutting a cable may have far-reaching effects on states that are not belligerents in the ongoing war. Now the question is, are you allowed to damage them? Yes. If they are military cables, absolutely. Or if they are being used for the transmission of militarily relevant data, absolutely. Difficult to establish, but possible. Now the question is, what about the loss of connectivity for other states? Yeah, that may have far-reaching effects. But the question is that damage? No. We are not here talking about insurance law, all right? We are talking about damage. And loss of connectivity, yes, you can no longer access your social media account, poor you, all right? It is very uncomfortable, you lose many amenities, but for heaven's sake, this is not damage, okay? So therefore, be careful here. Note, however, there are not only communication cables, there are also high voltage cables. There we are back to the old rules because those are only physically serving those states physically connected. Pipelines, likewise, may become lawful targets. Now, some of you may recognize this here. That's the Nord Stream gas pipeline connecting Russia with Germany. It was blown up. Now let's assume the Ukrainians did it. I'm just for the argument's sake, I'm not accusing anyone here, right? But let's assume, well, if they could say that the pipeline was making a contribution to the enemy's, Russia's, war-sustaining effort, remember the revenues from the gas sales? Well, that would have arguably qualified as a lawful target. Of course, this all depends on whether you adopt the war-sustaining approach or not. And finally, only two words. Natural environment. We are, of course, we love the natural environment. We are dependent on it. But you see, the problem is, we don't, even though we have rules, Article 35, paragraph 3 of the Additional Protocol, but it does not absolutely protect the natural environment. Only against damage that is expected to be widespread, long-term, and severe. Note the "and." Widespread, hundreds of square kilometers. Long-term, we are talking about decades. Okay? And severe means that the recreational elements will no longer suffice to reestablish the status that would have existed before. And then we have the NMOD Convention, prohibiting environmental modification techniques, for example, creating a tsunami. Oh, here you have, however, widespread, long-lasting, or severe. And remember, we talked about the Russian Poseidon, which may create a tsunami by a nuclear blast, devastating entire coastlines. That would most likely qualify as a prohibited attack under the NMOD Convention.